So we're going to do a little sham peer review update today, and I know that all of you in this room know what sham peer review is. It's peer review that's done in bad faith, that has nothing whatsoever to do with medical care. It's not related to professional competence or professional conduct. It's done for some other wrongful underlying purpose. Sometimes it's retaliation against a whistleblower, or it's an anti-competitive thing to knock out a competitor, and there's many other underlying reasons that it's done. And sometimes it goes beyond, sham peer review goes beyond simply unfair peer review hearings that are biased, where the outcome is predetermined. Sometimes it goes beyond that to actual physical actions that are taken against the doctor. And we've had, I think, 6 reports now of essentially tire slashings, where the doctor was a whistleblower maybe and involved in sham peer review, or filing a lawsuit against the hospital because of the sham peer review and the ruination or end of his career. And so here's one tire. This tire was submitted to a forensic tire expert. And there are people out there that can be hired, and these people apparently know how to do this, but the box cutter blade is inserted into the tire and broken off. When you do that, the tire doesn't go flat right away. What happens is when you take that car out on an interstate going 70, 75 miles an hour, the tire catastrophically fails. And then, there's an accident. Oh, the poor doctor died in an accident. That's all it was. And this is another case where that same thing was done. A box cutter was inserted in the tire, broken off. And in this case, it involved a rollover accident. And as you all know, rollover accidents are a very bad thing, often end up in severe injuries. In this case, the accident occurred while the physician's daughter was driving the car, and she had 2 foreign exchange students, which they were hosting at their home, in the car at the time that the tire blew and resulted in a rollover accident. No one, fortunately, was hurt. They all had their seat belts on, and no one was hurt. It's sort of a miracle. And you can read more about what they did to this doctor in our journal. If you look at the case, it's called The Shocking Case of Dr. Michael Fitzgibbons. They did a lot more to this doctor that I don't have time to tell you about today. So this is a case from another country. Sham peer review occurs in other countries. And this particular case also involved inserting and breaking off a box cutter blade in the tire. But it didn't work. And the reason it didn't work is the doctor had run flat tires. But that never seems to stop some people. So what was done next is somebody apparently drilled a very small hole in the fuel line next to the engine block, such that when the engine block got hot, it would ignite the gasoline and the car would explode. I suppose they hope killing the doctor, or it would burst into flames. And as you can see here, this was a brand new car, and it did burst into flames, and the doctor was able to get out of that without being hurt. This was a dentist, by the way. I'm not allowed to say his name, but he was a dentist in another country, not Canada. And I'm including this next thing on the presentation. It doesn't have anything to do with tire slashings, but this is a similar kind of thing where they take some awful action against the doctor. This was a doctor who was born in India, and he was a surgeon. And in the OR, there were some OR techs who were just bound and determined to harass him. So they would repeatedly say things like, the Indian physicians are stupid. But the most frequent thing one of the OR techs apparently said was, the best Indian physician is a dead Indian physician. That's what they said. And I will tell you that the hospital knew about this. There was testimony under oath by the vice president of medical affairs that said, yeah, he knew about this going on in the OR. He just thought they were joking around. Well, this hospital had a policy where you don't joke around and do things like this, and it's totally inappropriate. You shouldn't need a policy to tell you it's totally inappropriate. So they took no action against the OR techs. They were just joking around. That was sworn testimony. And so the doctor sent me this picture. He wasn't sure what RIP meant. So I explained to him the situation here. You know, they were sort of looking for him to die. And I don't know any other way to characterize these things, like the tire slashings and setting cars on fire and whatnot, other than to characterize it as evil, because that's what it is. We have to recognize it and call it what it is. And there are some precautions. You know, if you're suing a hospital or you're a physician whistleblower, involved in a sham peer review, you might want to take some of these prudent precautions. And this is a lighted mechanics mirror. And you might want to take a look at your tires before you're driving various places. And the reason for the telescoping lighted mechanics mirror is, at least in one case of the tire slashing, it was done on the median side of the tire. That is the side that faces the underside of the car. So simply walking around the car you wouldn't necessarily detect the broken box cutter blade. And of course there are cameras, and you can have multiple cameras in the car, which basically you can look to see who's approaching the car pretty much all the way around. Sure would be nice to get some of these folks on video that do this and prosecute them to the fullest extent of law. And I wanted to tell you about something else that we recently encountered. A young neurosurgeon was criticized for RVUs and conversion rates being too low. We all know what RVUs are, relative value units. It's the billing currency. But has anybody in this room ever heard of a conversion rate? Does anybody know what that is, other than the board members that heard about it? Yeah, a conversion rate, this was a surgery specialty. A conversion rate was the number of patients that he would refer to surgery over the total number of patients he saw in clinic. That's the conversion rate. So he was criticized, your RVUs are too low, your conversion rate's too low, it's lower than these other surgeons in your department, and you need to do better. That's all revenue-based. It has nothing to do with medical care whatsoever. So later, in an apparent attempt to eliminate the physician for failing to bring in sufficient revenue, the physician was criticized for performing surgery deemed to be too high risk. The physician successfully performed the surgery, however, saved the patient's life, and the patient's currently living at home, doing very well with minimal deficit. So a number of anonymous complaints came forth via the hospital's computerized complaint software, and an investigation ensued. Now, the neurosurgeon hired a malpractice attorney who, prior to the completion of the investigation, advised her to resign her privileges. Not good advice. You got to watch who you hire as an attorney. And a malpractice attorney is not necessarily an attorney that knows anything about peer review in hospitals, data bank reporting, or any of that. So this physician, the neurosurgeon, listened to her attorney, the malpractice attorney, accepted that advice and resigned. And of course, as we all know in this room, if you resign while under an investigation, you are immediately reported to the National Practitioner Data Bank, and the hospitals love this. It's a big win-win for the hospital because they get rid of you resigned, and you have no due process rights whatsoever under the peer review procedures in the hospital because you're no longer a member of the medical staff. The next thing that we encountered that I want to talk to you about a little bit is federally qualified health centers and their use of star chamber proceedings. So let me explain briefly. A federally qualified health center, it's a billing label, basically. And these are clinics and health centers that are in areas that serve underserved populations, and a lot of times they'll be in rural areas, and they get much higher fees from like Medicare and Medicaid. And the physicians who are employed there, guess who their malpractice insurer is? It's the federal government under the Federal Tort Claims Act. And so you cannot sue any of the employed physicians at one of these centers for malpractice. You have to sue the U.S. government. As far as star chamber proceedings, I should explain that just briefly. In the 1800s, under King Henry VIII in England, they had a star chamber thing where his people would meet in a room that had stars on the ceiling. They'd meet in secret behind closed doors, and they would determine the guilt and punishment of the people that weren't following the king's proclamations and directives. So the accused had no opportunity to, confront his accusers or even state his side of the story. And they would determine the punishment, and usually the punishment would be you either got sent to the Tower of London where you were imprisoned, or you got sent to the chopping block where you lost your head. So recently, I encountered 3 federally qualified health centers which use star chamber proceedings to terminate employed physicians and report the termination to the data bank. And I say they use star chamber proceedings because they had no peer review policy or procedure at all, none. They had no means, or they did not provide any due process. In 2 of these cases, the health center strategically waited until the practitioner had just started a new job or was just about to open a private office practice. So they were doing that to harm the person. Oh, you're going to get a job over here? Well, I think it's time we report that to the data bank. They're supposed to report it in 30 days, but some of them waited, a few months strategically right before, somebody's getting a job somewhere else, or that's going to open their own private cash-based clinic. So the health center officials in one case admitted under oath that the health center had no formal written peer review process. It's like, so what? We didn't have one. We've got an HR department. They can kind of do something like that. More devious schemes. A physician was employed by a powerful clinic in town. The clinic physicians held positions of power at the local hospital. He complained about not having proper equipment and staff to perform complex procedures. False charges were brought against the physician. A secret investigation was launched at the hospital. The hospital attorney and leaders at the clinic told him he should resign. Let me tell you, if the hospital administrator and the leaders, the so-called leaders at the hospital, tell you to resign, you don't want to do it. And again, we know what happens, before the whole peer review process has been completed. You resign, you get reported to the data bank. That's it. Career basically ruined or over. So the clinic pressured him to sign a separation agreement, and it made it sound like they were doing him a favor. Despite a non-compete clause in the contract, they told him he could practice anywhere locally except at the hospital that had launched the secret investigation. He arranged to be employed at another hospital, which was eager to have him on board. But the clinic wanted him to resign before he learned of the secret investigation. He didn't know the investigation was ongoing at all. So the physician signed the agreement and resigned his privileges from the hospital. Someone at the hospital then tipped him off about the existence of this secret investigation and urged him to rescind his resignation so he would not be reported to the data bank. So the physician was then left in a terrible situation. If the physician rescinded his resignation, he would still have privileges at the hospital and would be in violation of the separation agreement. The local hospital that wanted to hire him rescinded their offer due to the data bank report. And the physician is currently out of work, can't get on staff anywhere, with litigation ongoing. But I don't want to leave you with the impression that everything's bad. We've had some big wins that I want to tell you about. A hospital set out to destroy a physician based on anonymous false charges. The physician was labeled disruptive for bringing up difficulties with device acquisition, construction, and staffing issues. The physician was very proficient and skilled doing procedures and was the go-to person for complex cases. The hospital launched an investigation based on these anonymous false charges, and the physician was sentenced to undergo executive coaching for 6 months. With the help of a skilled attorney, the doctor was able to get the hospital to withdraw the request for corrective action. When the request for corrective action is withdrawn, that makes the investigation null and void, because the request for corrective action is what triggers the investigation. So the investigation was null and void at that point, which meant that the doctor not only had no databank report, but he would not have to self-report the investigation to medical boards, hospitals, insurance companies, or liability insurers. He emerged with his career and reputation totally intact. Big win. A settlement agreement was reached. The investigation closed. No pending or planned investigations, and they put that in writing. The physician was able then to safely resign from the hospital. But then you've got the rest of the story. Hospitals don't like losing, and some will look for ways to continue to harm the doctor. Approximately 2 weeks after the settlement agreement was reached, where the physician was reassured in writing that all investigations were closed, none were pending, and none were planned, the chief of staff sent the doctor a letter, and I saw it, informing him that they were looking into one of his cases and wanted him to respond. That's after he had resigned from the hospital, by the way. After the doctor's attorney raised the specter of fraud, the hospital decided not to pursue the case in question. Wow. Later, the executive coach, remember he was sentenced to executive coaching for 6 months. Later, the executive coach contacted the doctor and told him that a hospital official had pressured the coach to alter his positive report so as to report negative things about the doctor. The coach's report was very positive about the doctor, his ability to do things, communicate well with staff and whatnot, but the hospital was pressuring the coach to try and change it so that it would report mainly negative things. So another big win. This involved a physician whistleblower, anonymous complaints of disruptive physician, denial of privileges were affirmed by the hospital board, and the physician applied for and obtained an injunction to prevent the hospital from reporting to the databank. The physician sued them under the False Claims Act, and the case went to arbitration. So if you're employed by one of these hospitals, for example, a lot of times it'll be in your employment contract that if there's some dispute over employment, it goes to arbitration. So the case went to arbitration. The arbitrator ordered reinstatement of his privileges without conditions and a monetary award for damages, which was in the multi-millions. The arbitrator ruled that several named defendants had acted with malice. The hospital appealed. But appealing an arbitrator's decision is very difficult. I mean, the arbitrator had to have done something totally contrary to the law, which he didn't do. Most of these arbitrators are attorneys or maybe even retired judges. Very difficult to appeal and be successful on an appeal. So the physician recently prevailed on the appeal. So that case is done, it's over with. He got his privileges restored and he got back pay, and big win. Yet another big win, a federally qualified health center with no formal written peer review procedure terminated the employment of a practitioner and reported to the databank. The practitioner's attorney, who's sitting here in the room today, sought a preliminary injunction. A hearing was held. The judge found that the databank report was false and unlawful and ordered defendant clinic to void the databank report. And I remember seeing the expression on the face of the health center's attorney. It wasn't a happy expression. So in conclusion, what I want you to know is help is available for AAPS members. We have things that other medical associations just don't have. They don't provide. We have the AAPS Free Limited Legal Consultation Service, which is run by the nation's top attorney in Sham peer review, medical board issues, Andy Schlafly. And of course, I run the AAPS Sham Peer Review Hotline, where you can call, kind of present your case, ask questions, and I'm happy to provide whatever helpful information I can. Also, we have the AAPS archive of Sham peer review articles and presentations, and here's how you can get to that. And so you can go and look up on any particular topic you might be interested in the realm of Sham peer review, and take a look at maybe a video presentation or one of the articles on that. Most importantly, physicians are urged to engage the services of a knowledgeable attorney, and I underline knowledgeable, and contact AAPS early on. This is kind of like the COVID treatment. You don't wait until 3 years later and everything's kind of gone down the tubes and what do I do now? My career is about to be totally dead forever. Contact us early on, because there are things that can be done early on. As you saw in some of these big wins where we get them to withdraw the request for corrective action, there are things that can be done early on that might save your career. And the preliminary injunction is another thing that can be done early on. So I would emphasize that donations to our American Health Legal Foundation, which is the litigation arm of AAPS, and we do many things under the American Health Legal Foundation. The donations are fully tax deductible and greatly appreciated. You can donate online, and I thank you very much for your support. Thank you.